So the ATF is facing another major loss in the Texas case challenging the ATF's new rule against frames and receivers. So let's talk about this. But real quick before we jump into this video, if you think that the ATF needs to be abolished, go ahead and hit that like button and subscribe. Also, I want to thank one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense and liability protection. So if you carry a firearm, if you have a firearm in your home and you want to potentially protect yourself in self-defense, then you should probably think about getting some sort of protection, and I recommend USCCA. If you're interested, I'll leave a link to them down in the details section, and thank you again, USCCA, for sponsoring this video. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and a national level, while serving as a staff attorney with the Firearms Policy Coalition legal team. My goal with these videos is not to provide you any legal advice. This is not legal advice, but my goal is instead to give you greater insight into the inner workings of Second Amendment litigation and just help you understand what's currently going on in the battle for our right to keep and bear arms. As I mentioned in the intro, in this video, we'll be discussing the ATF and them currently facing another major loss in the Texas case challenging the ATF's new rule against frames and receivers. The case we're going to be talking about in this video is called Vanderstock V Garland. This is a lawsuit filed in the Northern District of Texas against the ATF and that new rule against frames and receivers, which went into effect in August. In this case, Defense Distributed, another manufacturer of 80%ers, is now seeking to intervene in this case and be added into this case as a named plaintiff. The goal of doing this and being added into this case as a named plaintiff would be then to go and seek the same preliminary injunction that other companies have already received from the judge in this case. As you may recall, recently Blackhawk Manufacturing Group, aka 80% Arms, was granted a preliminary injunction by the court in this case, which then barred the ATF from going after that company and its customers as well. The ATF did not want 80% Arms to be allowed to intervene into this case and become a new named plaintiff, because the ATF feared that Blackhawk Manufacturing Group, 80% Arms, if added into this case, would be granted the same preliminary injunction that this court already granted to another manufacturer called Tactical Machining, and that's exactly what happened in this case. This whole lawsuit arose out of the ATF's creation of their new rule regulating unfinished frames and receivers. This new rule by the ATF is essentially a restriction on the sale of 80%er kits. Under this new rule, 80%er kits are treated to actually be firearms. This new rule went into the regulatory definition of a firearm and changed the definition through a web of references so that now 80%er kits are actually defined to be actual firearms. Since 80%er kits are treated as firearms now, they're now subject to serialization requirements and background checks as well. In this case, Vanderstock, plaintiffs sued the ATF and are now seeking for a federal court to find that that new rule by the ATF is invalid and unconstitutional under the Second Amendment. In the lawsuit, the plaintiffs also requested a preliminary injunction from the courts to enjoin, i.e. halt the enforcement of the ATF's new rule while this case is currently making its way through the process. On review, federal judge Reed O'Connor granted a limited preliminary injunction against the ATF. Looking at the ATF's rule on frames and receivers, he found that it is facially invalid under the plain text of the statute and that Congress did not grant the ATF authority to regulate these types of items. So he granted a limited preliminary injunction in favor of one of the plaintiffs, one of the original plaintiffs, called Tactical Machining. Later, he then expanded that injunction, that granting of the preliminary injunction, to also protect the individual named plaintiffs in the case and also the customers of Tactical Machining. After that decision, Blackhawk Manufacturing Group sought to intervene into this case as a named plaintiff, and the court agreed that Blackhawk Manufacturing, aka 80% Arms, should be added into the case as a plaintiff. And as soon as they were added into the case as a plaintiff, they sought the same type of preliminary injunction that was just granted to Tactical Machining. And ultimately, the court did extend that granting of the preliminary injunction to that new manufacturer as well. In granting that new preliminary injunction in favor of 80% Arms, Judge Reed O'Connor stated that rather than cite its previous analysis with respect to the interpretive claims verbatim, the court incorporates by reference the reasoning in its first opinion. To summarize, the final rule purports to regulate firearms parts, including incomplete, non-functional receivers and weapons parts kits, contrary to the plain language of the GCA, which confined the ATF's authority to regulation of firearms, a term clearly defined by the statute. Moreover, the final rule's expanded definition of frame or receiver to include partially manufactured, non-functional receivers within the meaning of firearms, contrary to the GCA's clear statutory definition, is facially unlawful. Because Blackhawk challenges the final rule on these same grounds, the court similarly finds that Blackhawk has shown a substantial likelihood of success on the merits of its claims. The judge goes on to state that Blackhawk will clearly suffer irreparable harm, and that he already came to that conclusion when he decided in the prior preliminary injunction and already decided on the expansion of that preliminary injunction. Then the judge points out how absurd it is that the ATF claims that there will be no injury if Blackhawk simply just decides to comply with the new rule. He stated that in response, the government claims that Blackhawk could avert the injury by simply complying with the rule. But it is no answer to say that the plaintiff may avoid the harm by complying with an agency rule that is likely unlawful. And he states that as this court previously held, defendants' arguments relies on the incorrect legal premise that compliance costs are not an irreparable harm. So here Judge Reed O'Connor dismisses the ridiculous argument that all these companies need to simply do to avoid any injury is just to bend the knee to the ATF and comply with their rule. So in this case, the court and the judge has already expanded the protections against the ATF's new rule on frames and receivers to 2 other companies. In response to all this, Defense Distributed, a new company, is now trying to join into this case. They're trying to become a plaintiff in this case to ultimately get the same type of relief that's been granted to these 2 other manufacturers. This is kind of like them smelling blood in the water, and now all these manufacturers now want to get in this case and get the same type of protections against the ATF. The likelihood is that Defense Distributed will be permitted to intervene in this case and will become a named plaintiff in this case, and then they will likely just simply seek the same type of relief that was already granted to Tactical Machining and 80% Arms. However, one other thing to note is that in both of those situations, the ATF is not going to go away quietly. The ATF has filed an appeal to the 5th Circuit on both of those grantings of the preliminary injunction, both in the granting to Tactical Machining and 80% Arms. And the likelihood is that if Defense Distributed is allowed to join this case and is granted the same type of preliminary injunction, ultimately the ATF will likely appeal that decision as well up to the 5th Circuit. So this is something you will want to keep your eyes on, especially if you're interested in purchasing these types of items, since things can really change overnight and are changing overnight. Also, for those of you who have been asking, and you maybe live in states like California, and you've been asking how this will affect the laws in your state, this case is a challenge to the ATF's new rule on frames and receivers that went into effect in August. California and other states have their own state-level laws, which have restrictions on these types of items. For example, California has their firearms precursor parts law. So this specific case at this point does not change those state level laws. So you just need to be aware of that as well, that your state level laws are not affected by this specific case. So that's a quick update on the Texas ATF frames and receivers case. If we get any more information, I will let you all know. Also, if you like this video and support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. Also, for those of you who are asking me if I lost my right arm, I don't know why you're saying that, but no, I did not lose my arm. It's just because I have my arm down here and I usually wear a lot of black. So no, I didn't lose my arm. So for those of you asking, that's your answer. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.